What's up, tribe? How you guys doing? Y'all come on in, come on in, come on in. Hey, hey, hey. Happy Friday to everybody. Shout out to Kia Bell. Kia has been a member before. I believe she's just renewing her membership. So thank you for coming on back. Thank you for coming on back. Welcome to our new member. Yes, honey, yes. Okay. So we're about to get into the things of the things. First of all, let me say happy Mother's Day weekend to you all. I know that for some, this may be a hard weekend. I have 3 friends who have all lost their mom within the last 12 months. So this will be their first Mother's Day without their mom. And so I understand that this is not always a good time. What I'm going to say is, find some good friends, find something that's going to make you happy this weekend. I know it's easier said than done, but try to do that. Okay. The lip is popping. Thank you, girl. It's Juvia's place. This is fierce. I wore this. This is my little colorful right now. But all I did, it's a matte, so I just added a little lip gloss. I just added a little clear. I just added a little clear gloss to it. Little clear gloss. This is MAC. Little clear gloss. Okay. What up, everybody? So y'all come on in. So listen. Hit the like button. Get you a seat. We got a couple of things to go over. Now, I know that y'all been over at Pam's house this week, and Pam has been giving y'all the legal breakdown of the things. But y'all know we're going to go through the things, but y'all know we're going to, you are on the hood and ghetto side of the law firm. You know what I'm saying? You're on the hood and ghetto side of things. So we're going to get through it. We have 3 documents that we're going to cover. We covered one of the documents earlier this week, but we're going to get through the last. But the last one, baby, you're going to want to stick around for that last one. Because, baby, that last one, it's gonna be a key and a key. Thank you, everybody, with the lipstick. Thank you. It's funny how adding a little lip gloss will change. I've been wearing this. I've worn this lipstick a million times. Oh shoot. I've worn this lipstick a million times, but you add a little lip gloss, honey, and it's a whole new thing. Listen, this how much I done worn this lipstick. It's almost gone. Look, it's almost gone. But you add a little lip gloss to it, baby. So let's get into the things. Okay. Let's get into the things. So for those who are new here and you don't know who I'm talking about, I am so sorry, baby. You're going to have to go through the playlist. We have a whole Bishop Whitehead playlist. You're going to have to go through the playlist. But just to give you a quick update of the latest chapter of the Bishop Whitehead saga, we know that they are trying to, that Bishop was sentenced back in March. He was found guilty, He was found guilty back in March. His sentencing is July the 1st. But he decided that he was going to drop a podcast and do some interviews proclaiming his innocence. Now, the problem is not him proclaiming his innocence, okay? The problem that the state is having is that he came down here and he decided that he was going to have a podcast where he was going to show documents that allegedly were protected documents that the public was not supposed to see. He even bragged about it. And said, I have something that nobody else has. Y'all listening to them bloggers and YouTubers that don't know what they talking about, but y'all don't have what I have. Y'all don't have. He was holding up the paper that had the seal on the paper. Had the seal on the paper. Hey, Bama girl, Chuck, Symmetry, Quake, Ravine. Hey, Ebbs. Hey, Boo. Hey, Tracy. Hey, you guys coming in. Hey, Amber. You guys coming in. So what we're going to read, the first document that we're going to read through is his attorney's defense. Because the judge said, listen, let me know what's going on, okay? Because somebody wrote a letter to the judge. Now, this particular person, who we still don't know who this woman is, but I thank her for her service, okay? She wrote a letter to the judge, and even though she was out of order because she really wasn't supposed to be talking to the judge because she's not part of the case, the judge was like, even though you really not supposed to be talking to me, kind of want to know what you're talking about. So she asked Whitehead's attorneys to respond to what this woman was alleging. She asked the state to, submit some things. And then she said she was going to have a hearing on May the 20th. Remember that date, May the 20th. It's important. Remember that date that the judge said she was going to have a hearing on May the 20th. That's going to be important in a few minutes, okay? So the first document we're going to read through is Bishop Whitehead's attorney's letter to the judge defending his podcast and such, okay? So hold on. And shout out to Tracy and Pam. Well, Pam posted them and Tracy sent them to me. So shout out to Tracy. Shout out to Tracy and Pam. Okay, hold on. This is the first one we're going to look at. Okay, we're going to look at this one first. All right. Hold on, let me scroll down. I don't want to show any information that don't need to be up there. I don't think it's any private information, but okay. Let me share my screen. Oh, what? Thank you, Don Don. Hold on, Don Don gifted memberships over here. Hold on. Thank you, Don Don. We got some new members. Let's find out who the new members are. Let's find out who the new members are. Thank you so much, boo. That's my boo thing right there, Chef Don Don now. Y'all know that's my boo thing. All right. Let me get in this chat. I'm not even in my own chat. Ain't that some mess? Hold on. Let me share this live. I ain't even shared the live, child. We are live. Okay. Now let me see who got these memberships. Let's see it. Let's see it. Okay. Now let me see. All right. Diva Law 888. Vovo, Nina, Melly, and Dez Hop. You guys were all gifted with memberships. Thank you so much. Don Don, y'all, if y'all are in the chat, drop down and thank Don Don. I appreciate you. Angela. Okay, girl. Angela has become a member. Thank you so much, Angela. Hold on. Let me get back to the chat, honey. Let me get back to the chat. Thank you so much, you guys. I appreciate that. And like I said, we're going to have a members only live sometime in the next couple of days. I told y'all my weekend is really tight, but we're going to have one sometime in the next couple of days because I do have some things to tell y'all. I got some tea to pour. I got some Love and Marriage DC tea to pour. Matter of fact, this is what I'm going to do. This is what I'm going to do. I am going to, I'm going to do a members only after Sunday. Sunday I am going to Carlos's live show here in DC. It's going to have the ladies of Love and Marriage DC there. I'm going to go live. I'm going to do a members only from the show. So maybe Sunday night we'll do a members only when I get home, depending on how late I get home. Maybe we'll do a Sunday night. So you guys, members will be the first ones to get the tea from what happened down to the podcast. Y'all will be the first ones to get the tea, okay? So we'll do a members only either Sunday night or Monday. Sunday or Monday. But you guys, before I talk about it publicly, I'm going to talk about it with y'all, okay? All right. Moving on. So let's get into this document. Let me share my screen. Let me share my world. Here we go. Okay, let me get my reading voice together. Okay. All right. Okay. Sorry, y'all. I lost my place. Okay. So this is Lamore Whitehead, defendant. It says, Your Honor, Mr. Whitehead should not be remanded, and here's why. As an initial matter, the government claims in its submission that the documents displayed are USAO and USAO. They write what it is. Okay. Those documents were reproduced with a sealed designation. They're saying that 9914 and 9919 were marked, but in 3600 series, specifically 3604 through 01 and 3604 through 05, It is not immediately apparent based upon the screenshots or review of the podcast which versions are displayed. However, it is important to note that these materials were reproduced as a non-APO material. So the APO is the protective order, right? And what they're saying is, yes, there were documents that had the seal on it, and then there were documents that didn't. And yes, the bishop was holding up documents in his video that had a seal, but how do we know which document it was? Was it one of the documents that was a part of the series or wasn't a part of the series? And not only that, those materials were reproduced as non-protective order material, okay? The statement that, and they in quotes, the jury could not get this at all. You guys could not get this at all. This is exclusive paperwork, is a reference to this paperwork having not been presented to the jury. The statement regarding posting the paperwork on Patreon was intended to reference non-sealed materials. This is supported by Mr. Whitehead's statement that, and this paperwork is going to be the reason why this case will be reversed and overturned, right? And you guys have been destroying my life because the jury was not able to see this paperwork. This discussion is tied to Mr. Whitehead's contention that if certain evidence had been presented to the jury, the outcome would have been different, similar to arguments raised in the Rule 33 motion. Now, remember, y'all know they filed a Rule 33 motion asking for a new trial. So basically what they're saying is, here comes Jamar. You know, Jamar be trying to steal my man. Thank you, Abby, $1.99. Just know which Lolly have a countdown to July the 1st. Well, it's the final countdown. So they trying to say that he's not talking about information that he wasn't supposed to share at all. He's just talking about information that the jury didn't get to see. And then they start giving case law. Y'all know they're going through all the different case law. It says, it states the order in DKT 24 states is relevant part. The defense shall not post any disclosure material on any internet site, the network site, including any social media site such as Facebook or Twitter, to which persons other than the parties hereto have access, and shall not disclose any disclosure material to the media. This statement could potentially be read as not allowing the posting of that material as opposed to barring discussion of the material. This is additionally a reasonable misunderstanding of the order in light of the fact that the disclosure material includes at least in relevant part. So they're saying Mr. Whitehead did not reveal or attempt to reveal or display any material that will relate to the privacy of any individual, such as contact information. Mr. Whitehead did not reveal anything that could impede an investigation. Mr. Whitehead did not reveal anything which would risk prejudicial, pretrial publicity if publicly disseminated. In addition, the discussion related to Brandon Belmonte by the large reference matters, which have been the subject of significant and detailed motions available on the public docket, as well as matters that have been publicly discussed by Brandon Belmonte. Brandon Belmonte has given interviews about this case, including on July the 25th, an interview on Power 105.1, where Mr. Belmonte stated that Lamar Whitehead called Eric Adams right in front of me. Eric Adams did not pick up the call in any of the conversations ever. These matters were further discussed by Mr. Belmonte in a New Yorker article entitled How Eric Adams Started Mentoring a Con Man. We went over that article by Eric Latch. It was published January the 13th of 2023. The fact that these statements have been discussed publicly by Mr. Belmonte limits any kind of impact to any investigation or prejudicial publicity. Mr. Belmonte has publicly disclosed his role in this investigation and spoken at length about this conduct, making much of this information public. It does not appear that any information which was disseminated had not already been discussed publicly by Mr. Belmonte, both within the New Yorker article and the Power 105 interview. Mr. Whitehead had been specifically cautioned that even the discussion of such materials can be considered violative of the court's order and would not do so. So basically, they like, I didn't say nothing that I wasn't allowed to say. And even if I wasn't allowed to say it, Belmonte said it first. That's what I heard. That might not be what he said, but that's what I heard. I heard, even if I did say something I wasn't supposed to say, he said it first. That's what I heard. Hey, Winter. Hey, boo. Hey, what's up, Thais? Hey, Thais. Hey, boo. That's what I heard. Is that what you heard, Thais? I know Thais going to agree with me. That is what I heard. Okay. Let's keep going, honey. Let's keep going. Oh, we ain't even got to the good stuff yet, y'all. Ooh, we ain't got to the good stuff yet. Okay. The context of Mr. Whitehead's statement matters as well. Mr. Whitehead has claimed, consistent with Mr. Belmonte's statements in the New Yorker, that this was about Eric Adams. Specifically in the Latch article, Belmonte is quoted as saying, "I said I think the mayor of New York is on the take." And he said, "What do you mean?" I said, "The mayor of New York is trying to extort me through someone else." This is highlighted to show how the language regarding exclusivity and what the jury did not see are related to Mr. Whitehead's contention, which was alluded to in his testimony, but could not be fully developed, that this all has to do with Eric Adams. This shows that his overall intention was to criticize the prosecution against him as his right to not violate the order of the court. Now, let me tell y'all something. I've said this before, and I'll keep saying this, because I'm going to call a thing a thing. I'm going to always call a thing a thing, okay? I'm going to tell y'all the truth. When it comes to the Belmonte stuff, I don't disagree with a lot of what Whitehead has said. Did you hear what I said? I don't disagree with a lot of what Whitehead has said. But here's the problem. The problem is, you probably, listen, sir, anybody who has been around you for longer than 5 minutes knows that you were friends with the mayor. You have said it 5,672 times. You said as much as you will, as somebody will let you say it. You let everybody know that you and the mayor were like this. Okay. Now, do I believe that he was bragging? Do I believe that he said some stuff? Sure, I do. But do I believe that the FBI's original intent was to try to get the mayor? Of course. Why would they settle for you if they could get the mayor of New York? Hello, a duh. But here's what had happened, in my opinion. When they started investigating, trying to get the mayor through you, they took an exit off of fraud and deception, and they landed at your feet. See, sir, your hands were not clean. See, had your hands been clean, this caravan would have passed you by. This caravan would have passed you by. But when the FBI started doing a closer examination, they pulled out that microscope, okay, that magnifying glass. They found some things there. And when they realized that they weren't going to really be able to get the mayor, they said, well, hell, we'll settle for the next best thing. We'll settle for you. That's what had happened. That's what I think. That's my opinion. That's me. All right, let's keep reading. On the whole, Mr. Whitehead's statements have been indicative of frustration with the judicial process and the way the trial unfolded. They have been related to his protestations that he was innocent and that the outcome would have been different if Mr. Belmonte had testified. This is consistent with arguments made by the defense. There is nothing in these statements that indicates any intention to flout the order. And since the government's filing, Mr. Whitehead has not made additional public statements or released additional episodes of the podcast. He ain't released them, but he said he recorded them. But I mean, I'm just telling you what the man said, including his intention to comply with the court's orders. While the government's filing makes mention of Mr. Whitehead's supposed willingness to casually commit additional crimes as part of his media tour, However, there does not appear to be a specific allegation that Mr. Whitehead violated any order or committed additional crimes aside from those specifically enumerated in the government's motion. Let's put a pin in that. So, let's talk about this Belmonte situation. He is absolutely correct, right? Brandon Belmonte did not testify in front of the jury, right? He testified in a closed chain. I don't know. Y'all know I don't know the right terminology. I didn't go to nobody's law school, but he testified in in a room with just the attorneys and the judge. It was not in front of the jury, right? Now that is true. He is absolutely correct. He is absolutely correct. But for those of us who have been following this from the beginning, do y'all remember when Whitehead, and it's in my playlist, I'm sure I got videos on it. Don, I'm sure you do too. Hell, Thais probably got some videos on this. When he used to come down here and he used to yell at the rafters. He used to yell from the rafters that Brandon Belmonte was a crook and a criminal and that they need to arrest him. Do y'all remember him saying that? Do y'all put a 1 in the chat if y'all remember this man coming down here, going live? He was holding up. He did a whole thing where he was asking the victims to reach out to him. He did a live where he had victims call in that will have been victims of Brandon Belmonte. Remember when he was begging people, if you've been a victim, come forward. And this man is a crook. They got a crook. That's who the government is relying on. The government is relying on a crook. Okay, well, let me explain something to y'all. Now, I took my classes down to the law offices, my continuing education classes down to the law offices of Hood and Ghetto, because y'all know I don't have no real law degree, right? I got my law degree from Matlock College by way of Law and Order University. But let me explain to y'all what had happened. The government gave you what you wanted, sir. The government gave you what you wanted. The government said, oh, you mean he's a crook too? Brandon Belmonte, he's a crook too? Oh, you want us to arrest him? Oh, okay, sure. Let's go arrest him. So the government did exactly what you wanted them to do, sir. They probably would have done it anyway, but they did exactly what you wanted them to do. They arrested Brandon Belmonte. And you know what happened immediately once they arrested Brandon Belmonte? Because now he has federal indictments against him for all these charges that he's got going on over here. Do you know what his attorney told him to do? Plead the fifth. Don't say nothing. You know why Brandon Belmonte was not going to testify either for or against you at that trial? Because everything that he said could and probably would have been used against him in his own trial. Why would he come down there and admit to anything with you? He wasn't going to admit to having a conversation with you as it related to the mayor of New York, as it related to extortion, as it related to any of the things that he alleged happened between you and him. You know why? Because he got his own court case going on over here. So when you came down here waving all them sheets of paper and all this evidence about Brandon Belmonte, they did what you wanted them to do. They arrested him. And what the government said was, Your Honor, we've got phone conversations between Belmonte and Whitehead. So we're going to just play these phone conversations and let the jury make a decision because he's just going to plead the fifth. Now, to be fair, Whitehead said, well, make him plead the fifth in front of the jury, right? Make him plead the fifth in front of the jury. I wasn't there, and I wasn't there to argue for or against, but I understood his point. See, I'm fair because I understood his point. Make him plead the fifth in front of the jury. So anyway, that's what happened. Let's finish reading this because we got to get through this because listen, I'm telling y'all, when the government's response and then Whitehead wrote a personal letter to the judge. Baby, wait till we get to the Whitehead's personal letter. We're gonna I just want y'all to get the gist of what his attorney's arguments were. Okay, this is more case law, child. You know, this not the law offices. Okay. Mr. Whitehead has not knowingly taken action harmful to any witness with any intent to retaliate against them for their testimony. Again, the evidence here is lacking. There is nothing in the statements quoted that would seem to indicate that Mr. Whitehead took an action harmful to a person. He did not tell anyone to threaten Pauline Anderson, harass her, or contact her in any way, let alone that it was undertaken with intention to retaliate against her for her testimony. Mr. Whitehead has a right to criticize the prosecution against him, and it is absolutely possible to do so without taking an action harmful to a witness with intent to retaliate. Again, there are certainly edge cases that will go either way, but counsel does not see anything in the quoted statement that even approaches the conduct prohibited by the statute. Were the court to find that Mr. Whitehead had violated the order willfully, or that any of his conduct constituted harassment or taking harmful action against a witness, there are conditions short of detention which would be appropriate, even if the rebuttable presumption alleges by the government does apply. So basically, what they just said was, and even if he did it, you don't have to send him to jail yet. That's what he said. They said, even if he did all the stuff that they said he did, certainly you don't have to send him to jail yet. Like, certainly, Your Honor, you could find something else to punish him by, right? Because that's essentially what this is about. This is about the government is trying to revoke his bond and send him to jail like today. Okay. This, right, Cahoots, this is the official recap from the law offices of Hood and Ghetto. Absolutely. That is what we're here to do. Okay. Were the court to find that Whitehead had violated the order willfully, or that any of his conduct constituted harassment or taking harmful action against a witness, there are conditions short of detention, which I just read that. Sorry, y'all. Sorry. Whitehead has been released since December of 2022, approximately 18 months at this point, and he has not run afoul of the court orders or rules. I'm going to argue that he has. They just have not pressed the issue. But that's my opinion. That's just me. Counsel does not even specifically recall an instance where Mr. Whitehead has to be reminded of any order or caution by the court that his conduct ran up against the court's orders. When the government asked for Mr. Whitehead to be detained pending sentencing, the court found that Mr. Whitehead was not a risk of flight and did not pose any kind of danger to the community, and that he had consistently been in compliance with the court's orders and his conditions of release. Even when he has made public statements, those have all stayed within the bounds of court orders and dictates thus far. An admonishment by the court in the strongest terms would be sufficient. Were any content to be determined by the court to be a violation of any order, Mr. Whitehead will remove any offending conduct that is within his power to remove as soon as practicable. Practicable? Okay. Request that any content not within his power to remove be taken down, and refrain from any further public statement, action, or discussion which is even arguably violative. Mr. Whitehead has taken down the podcast. The defense submits that this would be sufficient to address these issues, and that there remain conditions on a combination of conditions short of remand which are appropriate here. Again, all you got to do is just talk harsh to him, Your Honor. Just talk harsh to him. You don't really need to do nothing. Mr. Whitehead, now this is important. I need y'all to hear this. Listen. Put this in your notes. I'm a teacher. When I get to a part that I know that the students are going to be responsible for later, back in the olden days when they used to actually use pen and paper, I used to say to them, this part is important. You're going to need to remember this. So let me know, this part is important. Mr. Whitehead has a wife and 4 children and is the pastor of a church. These individuals are dependent on Mr. Whitehead. Mr. Whitehead's family would suffer immense hardship were he to be remanded at this stage. Given the foregoing that the government has not met the burden of showing that the only condition or combination of conditions which can ensure Mr. Whitehead's attendance in court and his compliance with the court order. Okay, now that was February the 7th. Respectfully submitted, yada, yada, yada. Now that was February the 7th. Okay. Now let's get on over here. The government then responded. Let's get on over here to the government's response. Okay. Let's get on over here. Let me pull that up. We're going to read. We're going to read what the government said. Okay. Again, thank Tracy. We're going to thank Tracy for sending me these documents. Y'all know that Tracy be on top of it, okay? If you haven't done so already, now would be a great time to hit that like button, okay? Now would be a great time to make sure you have hit the like button. And if you are new here, go on and subscribe. It's 253 of y'all in the room. I hope we have at least 200 likes. Hope we have at least 200 likes. Okay, let's get into this next document. Now, this is the government's response, baby. This was the next day. On May the 8th, the government said, we got something to say. So, dear Judge Schofield, the government respectfully requests permission to file this letter providing an update in response to court's May 1st, 2024 order and briefly responding to the defendant's 2 briefs in opposition to the government's motion to remand the defendant. First, the government has spoken with the Andersons about the allegations contained in the email the court docketed on May the 1st. The Andersons are understandably uneasy about the defendant's public remarks, including remarks disparaging them, but the government understands that the defendant has not made any direct or indirect threats against them. Accordingly, the government is not relying on allegations contained in the email in its application to remand the defendant, nor asking the court to rely on or consider the email when ruling on the government's motion. So they said, listen, we talked to the Andersons and they said that Whitehead nor anybody representing Whitehead has come at them directly or even indirectly. They're not happy about, him keeping their name in his mouth. But, to be fair, they're like, no, he did not threaten us. Okay. But even if the Andersons have not received threats, the defendant has certainly taken steps to create risk to them. The defendant has falsely claimed that the Andersons could have been charged with federal crimes and that Miss Anderson's son was an informant for the FBI. Now, he said it. He said it. We talked about it down here, okay? In a video the defendant posted on Instagram on April the 23rd of 2024 promoting the April 30th, 2024 YouTube video discussed in the government's prior letter, the defendant talked about his intention to disclose a ton of paperwork that nobody else can get but me. That goes back to the documents being protected by the court. Sir, okay. The defendant... the documents he described as inside stuff. The defendant suggested he tell the audience a little secret. He said, what if Anderson and her son could have been charged with wire fraud? What if on April the 30th, I'm going to show y'all some stuff. What if Miss Anderson's son was the one who was behind it all? What if I show y'all that he was a federal informant? Woo-hoo! Y'all know that's how he would say it too. Y'all know that's how he said it. Woo-hoo! Oh, really? What if, just what if, the defendant stated in the video Miss Anderson's son was wired up and working for the FBI? Those claims are false. Excuse me. Government, please, if y'all need that video, I have it. Okay, moving on. Hey, Lisa. Hey, boo. Listen, government, if y'all need that video, I have it. If it disappears, it disappears. All right, let's keep going. The defendant of those claims were false and could have only been in an attempt to trigger harassment or harm to the Andersons for being witnesses against the defendant. That the risk created by the defendant's public remarks have not yet materialized does not excuse his public postings or making them any less concerning. Yeah, because listen, I ain't trying to make this a black and white thing, but we already know in the black community, you calling somebody an informant, a rat, they were wearing a wire. We already know what that is. We already know what that is. When you put out there that somebody was wired up or an informant, you know what you're trying to get people to do. Second, regardless of the defendant's conduct relating to the Anderson, his disclosure of documents subject to the protective order constitutes contempt. For the reasons outlined in the government section, then the section. The defendant's response on the score is most notable for what it doesn't say. It does not deny that the defendant knew about the protective order, nor does it deny that he knew the documents produced in discovery remained subject to the order, nor does it deny he held up or waved around or read directly from documents that were subject to the order. Instead, the defense argues that the order could potentially be read as not allowing the posting of the material as opposed to barring discussion of the material. That assertion is frivolous. So basically, he can read it, he just can't post it, but he was going to post it in Patreon. So even that argument is stupid. But okay, let me keep reading what they said because they went to law school. Let me keep reading what they said. Okay. Instead, the defense argues that the order. I just read that. See, I keep losing. Let me just read because I keep losing my spot. There is no reading of the protective order that permits the defendant to read entire documents on video as long as he does not upload the documents to a social media website. Nor does the argument explain how the defendant's conduct is consistent with the protective order provision requiring the disclosure materials be used only for purposes of this case. Similarly, it is no defense that the defendant did not reveal anyone's contact information or anything that could impede an investigation. The defendant is not entitled to make his own judgments about what should be subject to the court's protective order and to unilaterally narrow the order accordingly without court's intervention. And the defendant's own statements, including those quoted above, in which the defendant falsely claimed that Rashid Anderson is a government informant in order to cause him harassment or harm, believe the defense's the defense's suggestion that his public statements have all stayed within the bounds of the court. On this record, there is probable cause to believe that the defendant committed a new federal crime while on release, and the court should find by a preponderance of the evidence that there is no condition that will assure that the defendant will not pose a danger to the safety of another person or the community, that he is unlikely to abide by any condition or combination of conditions of his release. They said that the fact that he did it, he broke the law. The fact that he read documents that were supposed to be part of a protective order, he broke the law. All right, y'all ready? Finally, if the court is not persuaded that remand is required under Section 3148, the court should, at a minimum, reopen its consideration of the defendant's condition of release or detention. Bail conditions are not set in stone. Despite having continued the defendant's release after the verdict in this case, the court is authorized to amend a release release order based on the possibility that a changed situation or new information may warrant an altered release condition. The defendant's flagrant violation of the protective order and his numerous public statements disparaging witnesses and others are new information, and they warrant reevaluation of the court's decision post-verdict to continue the defendant's bail condition. If the court does reopen its consideration of the defendant's bail, his detention is mandatory under the statute, and he should therefore be detained. For purposes of release pending sentence, the Bail Reform Act divides convictions into two categories. In the first, more lenient catch-all category, the statute provides that a court shall order a defendant who has been found guilty and is awaiting sentence detained unless there is clear and convincing evidence that the person is not likely to flee or pose a danger to the safety or any other person in the community if released. In the second and the more stringent category, it requires the court to order detention for defendants convicted of, among other things, a crime of violence, unless they can make a clear and convincing show regarding under subsection A1, and either the court finds a substantial likelihood that a motion for acquittal or new trial will be granted, or the government recommends that no sentence or imprisonment be imposed. The defendant was convicted on count 3, attempted extortion, which is a crime of violence under the Bail Reform Act. Ooh. Ooh. And neither of the requirements of section 314A or B are met. Detention is therefore mandatory unless the court finds exceptional reasons for the defendant's release under section 3145C. But the defense has not identified any exceptional reasons justifying the defendant's continued release. The defense only proffered that the defendant has a wife and 4 children who are dependent on him, and that his family would suffer immense hardship were he to be remanded at this stage. As a factual matter, those assertions are believed by the information the defendant provided to the U.S. Probation Office in connection with the present investigation. Are we ready? In that context, he claimed that he has no income and his wife is supporting the household expenses. I'm going to pause for dramatic effect. And I'm going to read that again. He has no income. And his wife is supporting the household expenses. Also, the defendant's wife and children do not live with him. He resides alone. Now, that is the information that he told. He told that to the probation office. He told them people that. He also said the defendant is tens of thousands of dollars in arrears on child support and reported that he is not paying his child support obligation. I'm going to come over here and see what the chat talking about, because I know y'all talking. I know y'all are talking. What y'all saying? You knew it? People in the chat, gasp. Yes, Bishop, gasp. He broke, not surprising. He's broke. Woo child, here we go. Everyone told him to do the podcast and to stay quiet. We're either blocked or cussed out. Oh, well, you know, I've been blocked. Y'all know I've been blocked. I've been blocked since February. But I still see everything, Bishop. I still see everything. Yeah, I still see everything. I still see. I seen you. You can block me, but I still see everything, Bishop. Oh, gosh. All right. So his wife don't live with him. He's not paying child support, and he said he don't have no money. As a legal matter, they fail anyway. Exceptional circumstances exist when they... Oh, wait a minute. I just read that. I'm sorry, y'all. The fact that the defendant was the father of 3 young children whom he supports financially, combined with other personal circumstances relating to the defendant's family and job, do not rise to the level of exceptional circumstances. As a result, if the court does not detain the defendant under Section 3148, it should nevertheless order his remand because there is new information justifying a reopening of the court's release decision, and the Bail Reform Act mandates detention under the circumstances of this case. And then, of course, it is, respectfully submitted. Y'all, Now, before we go on to the letter, because the bishop wrote a letter. The bishop wrote a letter today. We're going to read through that in a minute. But before we get to that, I have a couple of exhibits. Okay, it's 261 of y'all here. I hope everybody is subscribed. I hope everybody hit the like button. Okay, and let's get into. Let me see if he took it all down. When I think about you, I think about. Hold on. I know where to find it. I don't want to tell my secret. Hold on. Do I have to tell my secret? Hold on. Give me a second, y'all. Because I don't want to tell my secret. So let me do it like this. Because the bishop, I see you. I see it all. Okay. So I just a few things. I just want to show y'all a few things. So let me make sure my volume is turned down. So as he was getting ready for his podcast, I just wanted to show you that he posted in this, Gucci suit with the Gucci socks. They're probably good. Those are probably Gucci shoes, okay? Gucci. Now, I ain't about to sit here and argue about whether it's real or not. Then we have him going live in this nice Louis Vuitton jacket. Now, listen, that jacket's cute. Now, I like the jacket. Whitehead, when you start selling your stuff, I know I probably can't fit it, but I like that jacket. Okay. Then when we go, here you go again, another Gucci Balenciaga jacket, the Gucci Balenciaga jacket. Okay. All right. Here we go. All right. Now, this right here is bad. I ain't gonna tell you no lie. This thing right here is tight. This Louis Vuitton jacket right here, oh, that's tight. That thing is nice. I would wear that. I would wear that. Now, I would wear that. I ain't gonna tell y'all no lies. I would wear that jacket. Okay. Now, I see a lot of y'all in the chat are saying it's fake. Let me say this. I can't attest to everything in that man's closet being real. But what I can attest to, because it was presented in court, that he did shop and he spent thousands of dollars at Gucci, Louis, Macy's, Fendi, because they submitted all that stuff in court. So I see that y'all are saying that some of those things are fake. Listen, that might be fine. That might be all well and fine. But some of that stuff he has is real. And let me tell you what ain't gonna happen. What you not gonna do is owe me thousands of dollars in child support and be walking your happy ass around in designer clothes, fake or real, and driving a Rolls Royce and you not. Did y'all ever see Waiting to Exhale? Oh, Gucci and Balenciaga had a collab. They did have a collab. Do y'all remember? Well, actually, let me not say that. I know Gucci and Adidas had a collab. Let me not say that Gucci and Balenciaga had a collab because that might not be. Let me rewind that. Let me rewind. I saw a video a YouTuber posted. Whitehead had the mobile Louis Vuitton van come to his house. Ooh. So, y'all remember that scene in Waiting to Exhale where Bernadette woke up? She came out of her depression. Actually, it was before she went into the depression. No, it was when she came out of the depression. I don't even remember. It's been a while since I've seen the movie. But she woke up one day and she started going back in her mind all the stuff that she did for that man. And she went through that man's closet. And she said, get your shit and get out. And she loaded up that baby's wagon. Remember, she loaded up that baby's wagon. And she rolled that wagon down to the garage. And she put all that shit from the wagon that was from his closet in that BMW. And she drove that BMW down the street. And she doused that car with the gasoline. And then she lit that cigarette. And she flicked that lighter. And she walked off smoking that cigarette down the street. Bitch, that'd have been me. Because let me tell you what you're not going to do. It's one thing. Okay, thank you, Green Girl. Green Girl said Gucci and Balenciaga did. I thought they had, but I said, let me not. The fashion police will come and get me if I'm wrong, but I thought they had. Thank you, Green Girl. Thank you. It's nowhere in hell that you're going to sit in my face and be prancing your happy ass around and fake or real designer anything, and you owe me thousands of dollars. Thousands. Was it her drive? I thought she drove it down the street. Maybe it was her driveway. I don't know, child. I don't even remember no more. I thought it was on the street because the police came by and gave her a citation. I thought it was on the street, but it don't even matter. Y'all know what I'm saying. Y'all know what I'm saying. You do know that the Louis jacket Don Staley wore for the Final Four was $9,000. I don't know how much it costs, but I'm just saying, like, you not gonna owe me thousands of dollars and be in my face with it. You're not gonna do it. I promise you, not. No, ma'am. Now let's get to this last part, y'all. Let's get to this last part. I told y'all this was a 3-part situation. So we heard what the attorneys argued. We heard what the government argued in return. Now, let me hold on. Let me see. Hold on. Okay, I just want to make sure I didn't miss no super chats, because y'all know when I'm reading, I can't see the chats. I want to make sure ain't nobody drop no tips on me. You can drop a tip if you want to, though. You can. I'll be all right with that. I wouldn't owe all that money with the closet of real clothes and bags. Well, that's true. Hey, Stormfluent. Hey. You also not about to be donating cookies down to the kids when you own it. Right. When you own kids. The Fendi backpack he wore after the verdict was $3,000. See, he wouldn't have it. He wouldn't have it. Anything that was real would be on eBay. I promise you that. The fake stuff he can keep, but any of that stuff that was really real, I'm telling you where it would be. Okay, now let's get into this last part. So I guess he woke up this morning and decided, damn, I might have really did it this time. I might have really did it this time. So he got up this morning and he wrote a letter himself. Now we're going to read this letter. I'm telling you now, I'm going to probably stop and commentate. Because this letter is comical. He woke up and wanted peace. I don't know what he woke up and wanted, child. I don't know what he woke up and wanted, but let's read through it, child. Let's read through it. First of all, thousands behind in child support as a pastor. His delegation seems like the same level of trash. Child, they but 5 people in that church, Angela. Don't even get mad at them people. It's 5 whole people in that church, child. It's 5 whole people in that church. First of all, he done put this on his letterhead from his church. That is his official Lamore M. Whitehead letterhead, child. He got a symbol and everything. Y'all see this? Y'all see this cut and paste situation he got going on over here? Do y'all see this? Oh. Now it's dated today, May the 9th of 2024. It says, Dear Judge Lorna Schofield. First of all, I don't know if you're supposed to be saying her first name, but I mean, I'm not going to nitpick. As my sentencing approaches, I continue to dwell on my conviction, and I've been in deep prayer and harmony with God. My attorneys know that I am writing you, Your Honor, and have advised me not to comment on the facts of my case or the jury verdict, given the motions they filed for my possible appeal. Still, I ask Your Honor to please consider my thoughts and reflections in this letter when determining the decision on this bail hearing. So first of all, you done already told the judge that your attorneys told you not to do this. You done already told the judge, my attorneys don't think this is necessarily the best idea, but I'm going to do it anyway. With this conviction, even though I maintain my innocence, I feel like a failure to my wife and 2 children. I think you meant to say, and to my children, but it just says, and 2 children. You know what? I'm going to give y'all the big screen. I'm going to let y'all see what I see. Hold on. I'm going to let y'all see what I see. Give me a second. I'm going to try to make it a little bit bigger so y'all can see what I see. Because, baby, okay. I hope y'all can read that a little bit better. Can y'all see? Y'all can see that a little bit better. Okay. All right. And I feel like a failure to my entire church, leaders of Tomorrow International Ministries. I feel like a failure to the people who look up to me. Who look up to you, sir? The men, women, and children worldwide. He said, the men, women, and children worldwide who listen to me weekly and every Sunday as I minister the word of God. Sir, them bots that you bought over in China do not count as worldwide. That is not, no, sir, no. I'm very hard on myself. I've been that way all my life. I never had a father in my life, so I had to find balance on my own. Other than my family, serving my church and the Christians worldwide watching me is the most important thing. I work hard to ensure Christians worldwide maintain the integrity of the Bible and what God has said. As a pastor, you must be trusted. Y'all are trying to keep a straight face. He said, as a pastor, you must be trusted. Sir, you were just convicted of stealing money from your parishioner. Sir, whether you admit that you are guilty or not, that is what you were just convicted of. You were just convicted of stealing money from those same people. Sir. Oh, my. Okay. I'm going to keep going. I'm trying, y'all. I'm trying. As a pastor, you must be trusted because you are seen as a man of God. However, after the conviction, the trust has been tainted. This conviction has hurt me in so many ways because I'm a public figure. I'm sorry, y'all. I'm trying. I'm really trying to keep a straight face. Okay, hold on. I'm sorry. Okay, hold on. Okay. I try to use my platform and the media interviews to give the people hope that the appeal will be successful and that I will be vindicated and restored. While trying to convey my innocence, I was told that I had violated a protective order of a sealed document. I never posted the document to any platform. I held the document in my hand during the interview. I did not know at the time that I wasn't allowed to do this. Okay, so first of all, you just admitted to doing exactly what the government said you did. That's number one. Number one, dummy, you just admitted to doing exactly what the government said you did. Dummy. Number two, ignorance of the law is no defense. You saying you didn't know that you weren't allowed to do it is not a defense to the fact that you did it. You dummy. Sir, you should have listened to what your damn attorneys told you. Your attorneys told you shut the hell up, and that's what you should have done. Angela's stupid. You need Abby to read this like she read Ted Lee's book. So you just admitted that you did what they said you did. And your only defense is, I didn't know I wasn't supposed to. While trying to, I just read that. Okay, but there's a document. I held it up. I thought this was public knowledge because the trial was over. And information in the document was already published in the New Yorker and told by Brandon Belmonte on the radio. See, here's where again, this is why people say, if you hire an attorney, let them do their job. This is why you wasn't supposed to say nothing, you dumbass. Because you, not only did you admit that you did what they accused you of doing, number one. Number two, now you contradicting yourself and you are flat out lying because you spent... And if I had the time, I would go back and play it for y'all. But you literally said, I got stuff that nobody else has. I have stuff that nobody else has access to. I have stuff, them bloggers and them YouTubers, they don't have this, what I have. Yeah, this the only place you're going to get it. This the only place you're going to get this information. So, sir, you knew that you were sharing information that everybody did not have access to in your own words. See, now you're going to piss the judge off. Now you're going to piss the judge off because you are straight up lying. But let's keep reading. I never gave any legal terminologies to the document, nor did I post the document on any site. It was brought to my attention that a motion was filed for contempt of the court for producing a sealed document. I would never intentionally disrespect the court or you, Your Honor. I have nothing but respect for this court and Your Honor. I've never promoted violence towards the Anderson family, nor Mr. Belmonte, public or privately. That's a lie. That's a lie. That's a lie. In them tapes they played in court, you threatened Belmonte. You threatened that. You threatened that man in court. You did. Now, I mean, after the conviction, I guess. But you threatened that man in court. Y'all know what my favorite line is that he told that man. He told that man that his wife had somebody else's balls in her mouth. That's what you told Belmonte. Me and Don ain't finished reading y'all the transcript. We're gonna get back to it, child. Life been life, but we're gonna get back to it. But baby, sir, you said it. You said it. I do not wish ill to anyone. The Anderson family, Mr. Belmonte, or any party of this case. I encourage love. I encourage love, he said, y'all. I have been on bail for over 18 months, complying with every rule and regulation given to me. I have not and will not break any rules that Your Honor or the courts give me. I humbly ask Your Honor to allow me to continue to stay on bail to further take care of my children. Sir, you just admitted you're not taking care of your children, my wife, my family, and my church as we prepare for sentencing. Sir, your wife don't live with you. Your children don't live with you. You got 5 members of that damn online church. You don't even have a brick and mortar. You are 100% online. Not saying that churches can't be successful online, but I'm just saying. Sir, what is there to take care of? What is it? You ain't got to turn the keys over to nobody. What is there to take care of? Your wife don't live there. She been left your ass. So what is she getting ready for? You not sending no money to your kids. As I'm meeting with my appeal lawyer and my trial lawyers to perfect the post-motion practice, it would be devastating to take me away from my 2 16-year-old children, my 9-year-old daughter, and my 2-year-old baby girl. Ain't that baby older than 2? I feel like that baby older than 2, but maybe not, child. Maybe not. I'm working to ensure that family and lawyers' fees are handled. Sir, you already said you ain't had no money. Even though I maintain my innocence, I feel like I let my family down. I have a lot of emotional days and nights and emotional prayers. I still believe God. Your Honor, when the prosecutors asked you to remand me after the conviction, you said that I do not present a flight risk, and I've maintained my integrity throughout these proceedings. I took that very seriously. I speak to the probation officer that I have to report to while on bail frequently. I always give her updates, even though it's not required. I promise you, Your Honor, that I will continue to hold up my integrity and abide by any court orders and any rules and regulations that you give to me. I apologize to the court if I broke any law or condition of my bail. Please know this was not done on purpose. This was an honest mistake. I did not mean to offend the court, and then I did not purposefully try to disrespect the court order. Please hear my heart. Thank you, Pastor, leaders of Tomorrow International Ministries. And then he signed it. Y'all. Yeah. Y'all. I guess Don, listen, and the grand, I ain't about to do the math, child. Okay, she two, child. She should be 3 soon, child. Yeah, that's what I mean. I ain't about to sit here. I thought she was older than that, but I ain't about to sit here and squabble, child. She 2, she 3, she 4, she 10. I don't know. I don't care. Y'all. That is the reason why they tell you have a right to remain silent. They tell you have a right to remain silent. And I'm going to say this, y'all. Y'all know I was down to the courthouse. That judge don't have the energy for him. Okay? The judge really don't be playing them kind of games with these people. The judge really wasn't playing these games with these people. Okay? The judge was not playing with these people. Lord, what did I do? Give me a second, y'all. I'm up here fooling around with this thing. All he do is lie. That's all he do. All he do is lie. Y'all, hold on. I'm playing around with these settings. This thing. I screwed up the settings. The lie detector said you lying. Whitehead want grace now, but didn't give any grace when he was cursing them out and calling them suckers. Right. I mean, he wasn't giving no grace before. Like now all of a sudden you want all this grace and you want people to, you want the judge. Now you all humble and everything. But you big dummy, you literally admitted to being guilty of what they accused you of doing, and your defense is you didn't know. And again, ignorance of the law is no defense. You can't say, how many times you ever got pulled over for speeding and you say, oh, I didn't know, and you still got that damn speeding ticket. Ignorance of the law is no defense. Child. Anyway. I ain't laughed so hard at something in my life until today. Thank you. Welcome, Marco. You are welcome. He was way too ignorant and yes, listen, Winter, baby, listen. I know we overuse the word narcissist, right? Everybody think that they understand what a just because somebody does certain things, all of a sudden they are a narcissist. But I honestly think that there's a case to be made that this man deals with some narcissism. Like, I really think there's a case to be made. The judge needs to block his letter. She ain't gonna block it. She gonna use. Well, I ain't gonna say what she gonna do. But if it was me, I would read the letter and say, so you admit that you did the things that they accused you of doing. Now, if I remember correctly from last night's staff meeting, baby, you don't need a case. Slap his photo by the definition. I know that's where I went to. I know. Now last night over at Pam's house, we took a class, and if I remember correctly, she said that they have moved the hearing up. So the hearing is no longer going to be May the 20th. I believe the hearing is going to be on the 13th, which is Tuesday, I think, Monday or Tuesday. Yes. I believe that it's going to be Tuesday. So it's Tuesday the 14th. I think Tuesday's the 4th. Whatever day Tuesday is when I believe this hearing is going to happen. So if you are not a member on Pam's channel, that is where that is probably where you're going to find your most up-to-date information. If you are a member on Pam the Law Intellect's channel, she will probably post, if something comes out, she'll probably post it. Y'all know that between myself, Pam, Chef Don and Tracy, y'all know if anything comes out on Tuesday, y'all know y'all gonna get it, right? So if anything comes out on Tuesday, y'all gonna get it. Okay, Monday is the 13th. So I believe it's Tuesday. Whatever the day Tuesday is, I believe that's what it is. It's either Monday or Tuesday. Oh, y'all are telling me it is on Monday. My bad. Okay, it's on Monday. Thank you. I had the date wrong. My apologies. It's on Monday. So, but my point is the same. As soon as I find out something, Pam, Don, Tracy, y'all know all of us. With that being said, y'all, I'm about to hop up off of here. There's 300 people still in the chat. If you are new here, please subscribe to the channel. If you haven't done so already, please hit that like button. I appreciate the new members that joined during this membership. Thank you, Don, for gifting the memberships. Thank you, Abby, for the super chat. Thank you, anybody, for any cash apps. I don't think I got any, but I always say that because sometimes cash apps come through after I get off, and I always feel bad that I wasn't able to thank people before I got off. So thank you, anybody, if you sent a cash app or will send a cash app. If you're catching this in the replay, still hit that like button, please, and thank you. All right, I will talk to y'all later. Mwah! Peace.